Leland Vittert, more proof today that we are truly in unprecedented times. If the FBI is to be believed, and a federal judge did, there is probable cause Donald Trump violated the Espionage Act. Let that sink in for a second. A former president of the United States accused of harming the United States. That is, in a word, huge. There may not be a word for it in the dictionary. However, on this program, we like to say two things can be true at once. Team Trump and the former president contend that as president, he declassified the documents found by the FBI at his club turned office and Florida residence Mar-a-Lago. That is very possibly true, and it's also true that it may not matter because the Espionage Act doesn't require the documents in your possession to actually be classified. Why? Well, the espionage itself, the now unsealed search warrant and evidence reference Title 18 of the U.S. Code, Section 793, covering the unlawful retention of defense-related information that could harm the United States and or aid a foreign adversary. Doesn't say anything about classified documents. The former president's lawyer signed a receipt from the FBI for the taking of one set of top secret, sensitive, compartmented information. Those are the most sensitive secrets our country has. 4 sets of top secret, 3 sets of secret, 3 sets of confidential documents. Again, the president says he declassified them all, and thus there is no crime. There was no reason for an investigation. He says he would have given the FBI anything that they had asked for. There's some serious questions about that. He may have declassified them before leaving office, but again, that might not matter. Put it aside for a second, whether or not he declassified them or not. And let's stop the cable news hysteria that either Trump was framed by the FBI, planting evidence, or that he will soon be put in handcuffs, because we heard both today. Neither are true, and the speculation is kind of stupid. What we didn't get today is what really matters: the FBI agent's affidavit justifying the search. That affidavit is still sealed. We don't know what the FBI told the judge they knew or were looking for or continue to look for, or where their investigation is headed. I said something, though, at the top of the show that should have given you pause. If the FBI is to be believed, one of the most serious times in American history, the 2 primary players have shown a casual relationship to the truth. The FBI's misconduct related to President Trump dates back to before he was president. It's real. And it's scary. And President Trump's relationship with the truth speaks for itself. Now it's time for someone smarter than me, which we hope most of our guests are. At least we endeavor for them to be. Bob Driscoll, former Deputy Assistant Attorney General. All right, Counselor, I get anything wrong?
No, I think that was an accurate summary. I think that the Espionage Act, just so your audience knows, is kind of mistitled because it does not have to do with anyone necessarily being a spy. It has to do with the handling of national defense information. And you're right that it's a way to avoid the classification question, because the Espionage Act was passed before the classification system was developed. So it refers to national defense information, and that will be, so the classification issue could be relevant to whether or not it is national defense information, which a foreign adversary could use, but it will not be dispositive. It's not a defense to an espionage charge that the information may have been declassified.
What is the relative chance, and this is now pure speculation, of the president being charged with something under the Espionage Act, or of Merrick Garland pulling a James Comey, holding a press conference and saying, we've investigated, while there was documents, there was no evidence that he gave them to anybody, and we're confident that all of the documents have been returned to a safe place. Thank you very much.
I think it's impossible to know without the affidavit. I mean, as I speculated last night, that the warrant wasn't going to tell us much. It would give us the statutes and give us that they took a bunch of documents, and that's what we got. I mean, it's helpful to have the Espionage Act and the obstruction statute cited, but I mean, I think we could have guessed there would have been, similar statutes or those statutes exactly. And so, without knowing why the documents were taken, why they're sensitive, not every one of these violations would get prosecuted. The Espionage Act, I think, most commonly is used for reporters who have leaked information, been the recipients of leaks, Government has aggressively used the Espionage Act against them, and also government workers who have kind of left or mishandled national defense documents. So I think it's really hard to know if he was, taking a memento would be one thing. If it's nuclear secrets, and did he have plans for them, that's another. But we just don't know any of that because we don't have the affidavit, and we won't have it probably for a long time, if ever.
Well, unless he's charged with a crime, right? Or someone is charged with crimes. You think about the Trump timeline of the raid. May 2021, the National Archives contacts the Trump team. January, National Archives receives 15 boxes of documents. May, the DOJ is officially involved. June, DOJ meets with the Trump team. There's possibly a subpoena involved in this. The president said, his lawyer said last night on this program, hey, look, all they had to do was ask and we would have given them anything. How does that jive with there being this raid?
Well, I mean, a subpoena is a fancy way of asking.
Right.
So I think we need to be squared with what you said. And I'm not necessarily not believing her. Maybe there's miscommunication. But I mean, subpoena is a formal request from the government. So if you complied with subpoena, there would be nothing to get. There must have been some kind of disagreement, or there must have been a set of documents the government was previously unaware of that they felt the need to go get. And again, it's all speculation at this point, but I suspect there could be discrepancies between the inventory that was given to the government early on in this process, and then someone came forward and suggested there were other documents that weren't previously disclosed that were there. Because for whatever reason, DOJ and the FBI stopped trusting the lawyers they were dealing with on the Trump side. And like you said, neither side comes to this with clean hands, so it's hard to know kind of who to believe in this circumstance.
Which is an incredibly troubling thing when you just sort of zoom out and think about this. President Trump's attorney on the program last night talking about their issues with the FBI. Take a listen.
I would actually blame the FBI themselves. I mean, it's not an isolated incident. This is not Trump saying, oh, the FBI is bad, go hate the FBI. The FBI lied to the FISA court. They lied about Crossfire Hurricane. They lied about Hillary Clinton's emails. They've lied about unmasking. Like, they've lied across the board. So this is a series of things. So I don't believe we can blame this one incident.
That's not a defense, though, right?
No. I mean, it's worthy of saying, and if you're a defense lawyer in that circumstance, you want to say it. But I think it's a classic example of what we call an argument that proves too much. It's an argument that would be could be used against literally any charge brought by the FBI. And so unless you're going to say that the prior misconduct makes one immune from prosecution, or immune from investigation, or immune from being searched, citing all the FBI's past misconduct only gets you so far. It might get you a reason to be skeptical, but you still have to go through the process of proving that you didn't do what it is alleged you're doing if you eventually get charged, or proving that there was no basis for the search warrant if you want to eventually challenge and suppress the evidence. So you're going to have to, and his lawyers are going to have to explain at some point, here's the process that we did, here are the communications the lawyers had, here's why we were being reasonable, and here's why none of this information is sensitive enough to merit prosecution under these statutes. But I would add that the obstruction statute being added is interesting to me. I didn't see that coming, because what I want to know there is, what is the proceeding that the government is saying is being obstructed?
Interesting.
Is that just the Presidential Records Act? Because that's a 20-year statute, and that was one I was a little bit surprised to see that they included that.
Wanted to get you on this, and there is this ongoing debate now about whether or not these were declassified, which, if you look at what they're alleging or what crimes they are investigating, it doesn't matter whether they were classified or not. So it's kind of a silly argument, but it's important for at least President Trump, because that's what he's arguing. Whether or not that is meaningful or not is yet to be found. PolitiFact, which by no means is a fan of President Trump or gives him the benefit of the doubt. Stephen Aftergood, director of the Federation of American Scientists Project on Government Secrecy, so conceivably he knows what he's talking about. Not really sure why it says Politico, but it says PolitiFact. Said that such authority gives the president the authority to classify and declassify at will. Is that absolute?
Well, I think there'd be a legal challenge, but I think the government doesn't want to go to that legal challenge, which is why they're looking at the statutes they are, because this has to do with, this is really a constitutional issue, that the executive branch's right to classify information comes through the president's executive branch authority under the Constitution. And so even though there are regulations and other things on the books, executive orders that exist with respect to the procedure to do this, there is a constitutional question of is the president even capable of violating those? Because the whole ability to classify and declassify stems from him anyway. So I think there would be an argument if it were fought. The president's people would have a very good argument that the classification authority is very similar to the pardon power, and that it essentially is plenary and absolute. Now, there's arguments. There's a statute with the Department of Energy that says only the Secretary of Energy can declassify certain nuclear materials. But those would all be challenged, because I think the legal theory would be all the classification process stems from executive branch authority.
All right. Hey, Bob, thank you for taking this through us. Not something we expected last night, the Espionage Act, and here we are this morning. So there will be more twists and turns that we don't expect. Always worry about the wrong thing, as a good friend of mine says. Good to see you, Bob.
Good to see you.
Thank you. Thanks for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to subscribe. Click the red button to get more of NewsNation's fact-driven, unbiased coverage.